All rise. The Lawyer of the Apes is now in session. Hey guys, how's it going? Welcome to episode 7 of Lawyer of the Apes. Today's episode is entitled AMC to the Moon, Griffin is a Buffoon. Listen up, guys. I just went over the reply papers to the motion to dismiss. So just to backtrack for anybody who might be listening for the first time, the complaint was filed. There were 2 complaints filed. One was an antitrust complaint and one was a class action complaint against Robinhood. The antitrust complaint, which is against Citadel, a variety of other brokerages, and Robinhood, was filed. And then the defendant filed what's called the Rule 12 motion to dismiss, then, which I went over in another video. Then the opposition papers were filed by the plaintiff. That means that the plaintiff is saying the case should not be dismissed. It should go forward to the next stage, which would be discovery. And then after someone submits reply papers, they get this opposition papers, they get to submit reply papers. So the process in motion practice is motion, opposition, then reply. Sometimes by leave of court, you can ask for what's called a surreply, and then sometimes they do oral argument. In this case, it doesn't look like there's going to be a surreply, and it does not look like there's going to be oral argument, which means the motion papers are going to be taken on submission, which means the judge is just going to read the papers and make a decision from there. Usually it takes about 60 days from the date of the documents are submitted for the judge to make a decision. Documents were submitted on October 5th, so we should expect a decision on or before November 5th. That's, being hopeful. There's been a backlog in a lot of cases. It's a lot of judges' decisions because of COVID. So, there's a possibility that it could take a little bit longer than that, but not much longer. I would definitely anticipate that it'll be decided before Christmas and probably before Thanksgiving holiday. So with that said, let's take a few minutes to go over the reply papers. Now, I had a really long day. I didn't want to not get a video out to you guys today, so I'm going to go through this a little bit, but I am a little wiped. So it'll be a short video today. It's the reply papers. Look, in reality, reply papers, are basically a reiteration of a lot of the things they said in the, in their main motion. To a certain extent, they attack, some of the points that the plaintiff made in their opposition. But most of the time when a person writes a motion to dismiss, they anticipate the arguments that are going to be made by the other side in opposition. So a lot of times they cover it. There were 1 or 2 arguments that the plaintiffs raised that were outside of the motion to dismiss. But for the most part, this is all just a reiteration of all the nonsense they said before. So let's dive right in and take a look. Just a refresher, this is the format of motion practice. They have a cover page, you have a table of contents, you have your cases that you're going to rely upon, and then you're going to have some rules and then other various authorities. So, all right, so they start off right off the rip with basically a recitation, reiteration of what they said prior. After 8 months to consider their claims, reviews of tens of thousands of pages of documents produced by the defendants concerning the relevant events in 3 rounds of complaints, plaintiffs have utterly failed to plead a cognizable antitrust claim that can survive a motion to dismiss. Again, they keep harping on the fact that the plaintiffs in this case had some discovery because of the subpoenas that were issued. But again, it doesn't matter. That's not going to get the court can't look at it from that perspective. They have to look at it from the perspective as if they had nothing. This argument that they keep saying that, well, the plaintiff had something, so therefore it should be looked at in a different light. No, there's no requirement that the court has to look at it from a different light. They can look at it from the perspective that there was no discovery, because technically in reality, there was no discovery. That discovery was not discovery done by the plaintiff. That was just documentation that they were lucky enough to get. So in reality, there was no discovery. So there really were no documents to, review that were produced by the defendant that were relevant specifically because the plaintiff themselves were not the ones that issued those demands for the documentation. So this is all just like smoke and mirrors. What is missing from the complaint are sufficient factual allegations of any agreement any attempt to identify any benefits that any brokers received from allegedly restricting and helping Citadel, any plausible explanation of how a conspiracy arose that resulted in members imposing restrictions, et cetera, and so forth. Again, we went over this the last time. This is more regurgitation of the idea that they're saying that there was no proof of any type of, benefit that would be gained by the parties from doing what they did. But like we said prior, the golden goose for Vlad and company is Citadel. Without them, they're not getting paid for PFOF. So in reality, it's very clear that there is some benefit to be derived from one back scratching the other. So they just keep dodging this issue by just asserting over and over again, there's nothing to see here. But that's just, most, judges most likely gonna, at least consider it. They're not gonna look past it because they're asking them to do so. Plaintiffs boldly proclaimed that this is a rare case in which there is direct evidence of a conspiracy, and then immediately walk that back by conceding that none of the cited documents actually reflect an agreement at all. And then they cite to one of the sections of plaintiffs' opposition papers. This is a complete misconstruction of the way the papers are laid out by the plaintiff. They do assert very strongly that there is direct evidence of a conspiracy, and they cite to a multitude of emails and interoffice correspondence. And this assertion that they backtracked at some point, it had nothing to do with those agreements. They make a statement during one section of their briefs where they basically say that there was one document that didn't assert an agreement, but it had not. And remember, we were talking about this previously. We have to look at things in their totality, not just one particular instance. And they're trying to make it seem like the plaintiffs were like, well, there's an agreement, and then all of a sudden they said, well, maybe there's not. There was nothing of that. This is being taken completely out of context by the defendant. Courts must determine whether the complaints contain allegations plausibly suggesting an agreement. Remember, plausibility, that's the standard that was set forth in the Twombly case that we had discussed previously. Plaintiff boasts that this is a rare case in which there is direct evidence of an agreement. Plaintiff retracts this baffling assertion when they concede in a footnote that the written communication appear deliberately vague and do not describe the contents of what was agreed to. Again, this was one instance in a footnote referring to one of the multitude of interactions where they asserted that it was unclear or vague as to what was going on. And remember, they said that because that was in relation to an off-the-record phone conversation. And remember, there were plenty of other direct conversations in emails. So this assertion that they retracted is completely made up. They didn't retract anything in regards to their repeated establishing of a direct conversations between Citadel and Robin. And this was just one of a multitude of instances. So just one instance being described as being not vague, that's just them being honest. They're being honest and saying, look, we don't know what was said in that one phone call because it was done, off the record. And if it was done off the record, what was the reason for doing it off the record? Obviously, the assertion is that they were trying to hide something. So again, this is all a lot of, deflection. The communications between Robinhood and Citadel do not contain or indicate any agreement to restrict trading in any security. Again, obviously, that's just not true based upon the allegations that were submitted by the plaintiff. Without direct evidence, plaintiffs are left to pledge circumstantial evidence of a conspiracy, parallel conduct, and sufficient plus factors. So remember, if the judge doesn't find that there is direct evidence, then it's not deemed a per se conspiracy. Then they have to plead a circumstantial case. And if they're pleading a circumstantial case, they have to show parallel conduct and sufficient plus factors. So that's basically like a little bit of a flow chart. So we have, direct evidence, per se conspiracy. Then you have, if it doesn't establish that, then you move on to circumstantial evidence. And then they have, in order to prove circumstantial case, then they have to show parallel conduct and sufficient plus factors. So there's two additional prongs to the test for circumstantial. It's parallel conduct and sufficient plus factors, not one or the other, but both, because there's an and. If it said parallel conduct or sufficient plus factors, then it would the test could be one or the other. In this case, it's both. The court may infer from factual allegations in the complaint obvious alternative explanations which suggest lawful conduct rather than the unlawful conduct the plaintiff would ask the court to infer. So again, this goes back to what they said previously. This is a very repetitive thing. That's why reply papers are usually kind of boring. They're just a reassertion of stated facts from the previous motion. Again, they're saying, look, this isn't on us. There's a reasonable, plausible explanation for what we did. It had nothing to do with, trying to screw retail. It had nothing to do with taking away the buy button in order to benefit the shorts. This had to do with the fact that market conditions were volatile. Because market conditions were volatile, we weren't going to meet our requirements, and if we wouldn't have done that, things would have gotten much worse. So they basically keep reasserting that they had no choice in the matter. This was our backs were up against the wall. We had no choice. Of course, they're going to say that. That's a self-serving statement. They're not going to admit, obviously, that they took away the buy button. So they had to come up with some type of theory of their case. And this is the theory of their case. The question will be, will the judge buy into their theory, or will the judge believe the more plausible theory, which is that this was done in an attempt to circumvent the market and to benefit the short sellers? The argument that this is something that is a market factor that happens, an outside stimuli, is ridiculous. This is not the first time something like this has happened. This is the first time something like this has happened, and it's gotten so much attention. But this is not a first time this has happened type situation. There's been plenty of short squeezes over time. There's been plenty of market volatility over time and through history of the markets. When I speak to Lisa, we'll get into this more, and she could, get into it in more detail with her history with the SEC. I'm not an SEC lawyer. I'm an attorney who just knows, a lot of different types of law and reviews different types of cases and has handled some appeals. So I'm familiar with these types of formats and the case law that is being cited to. But to have an SEC expert and to someone who can really get into the nitty gritty, that's going to be really beneficial to have that discussion and talk about these things. The fact that parties not alleged to be members of the conspiracy acted similarly as alleged conspirators indicates that the restrictions arose for permissible business reasons. Again, they keep asserting that this was business as usual. Okay, so then I didn't want to skip over this. Plaintiffs claim that defendants engaged in virtually identical, highly correlated conduct, and that this implies the existence of an alleged conspiracy. Plaintiffs do not plausibly explain how a conspiracy could involve disparate restrictions on varying durations pleaded here. Again, this is the section similar to the section last time where they're saying, basically, listen, this doesn't make any sense. If you're saying that there was a conspiracy, then why would all of the brokerages acted differently? Why would some have acted more strict than others? Why would Robinhood, completely take away the buy button, but why would E-Trade and other companies, not do that? Well, the rational explanation is those other companies did what a normal brokerage would do. They didn't fully take it away. They would maybe do some limits on the trading, because that may have been necessary and that may be standard market practice. But in the case of Robinhood, there was no limitation. There was a complete removal of the buy button, which is completely unheard of. And they're completely glancing over that. And that's really the key. That is what the plaintiffs have to really focus on, that this argument that the other brokers didn't act in accordance with everybody else, that doesn't mean anything. The reality is that they acted in a way that may have been, they should focus on the fact that Robinhood took the buy button away, and that the other brokerages, they did do other things, but they may have done so more in line with what a reasonable brokerage would do. Again, I'll get into more of that with Lisa on Friday. First, plaintiffs failed to articulate a plausible common motive for defendants to engage in an alleged conspiracy. The only common motive that plaintiffs assert is that defendants had a collective interest in maintaining their mutual beneficial business relationships. Again, yes, that's what we talked about last time. They had this beneficial relationship, and basically the golden goose for Vlad is Citadel. And if they were to lose them, they would lose a boat ton of money. Plaintiffs argue that Robinhood initially attributed the trading restrictions to market volatility, only to later assert that clearinghouse collateral requirements forced Robinhood to impose said restrictions. This is not inconsistent and conflicting. Rather, market volatility led to increased collateral requirements. Again, this is a nonsensical argument. They're completely trying to backpedal on what happened. Even if plaintiffs had adequately alleged an agreement, and they have not, they still have not adequately pled their antitrust claims because their alleged conspiracy cannot be subjected to per se condemnation, and the complaint fails to define the relevant market, adequately allege market power, and plead anti-competitive effects as pleaded with the rule of reason complaint. Plaintiffs' allegations do not fit within the narrow category of cases to which per se treatment is confined. Per se treatment is typically limited to horizontal restraints imposed by agreements between competitors. Again, they keep alleging that there is no horizontal agreement between the parties, but based upon the way the structure of the agreements were set up, it does show that there was horizontal constraints. They argue in the alternative, either that all defendants are competitors in the same market, so that the alleged conspiracy would be horizontal, or that even though Citadel Securities operates at a different market level from any of the defendants, plaintiffs adequately have pleaded a so-called hub and spoke conspiracy. Here they set forth the elements of what a hub and spoke conspiracy are, and they basically are just saying in turn that they disagree with plaintiff's assertion that this is a hub and spoke conspiracy. They're saying that the plaintiffs have not established that, but based upon the papers that were submitted by the plaintiff, it does appear to be a hub and spoke conspiracy. It just really needs, it's going to depend on how the judge, this is a factual issue, so the judge will have to decide if factually the way the setup is, the way the conspiracy was structured is if it fits within the category of a hub and spoke. While they attempt to rely upon in-ray disposable contact lens, which is a case that had a similar set of facts, the court there explained that relevant agreement to restrain trade was not the hub's vertical contracts with the spokes, but rather the horizontal agreement that the hub organized among the spokes, which was per se unreasonable. Plaintiffs failed to allege the agreement is so plainly anti-competitive that no elaborate study of industry is needed to establish its legality. Specifically, per se treatment is limited to naked restraint of trade with no purpose except stifling competition. Again, I don't see how that's not the case here. There was no other purpose for what was done other than stifling the retail trader from being able to purchase stock. Now, their argument, of course, will be there was one other purpose, and the purpose was to cover their butts. But covering your butts isn't really, something that is that I would not consider to be a valid defense. Examples of strategies are price fixing, output limitations, group boycotts, and horizontal market division. Now, in this case, this was not a price fixing scheme. This was not a group boycott. This was not a horizontal market division. This was an output limitation, which means they limited the amount of stock that was able to be purchased. They're saying that that's not true. That hasn't been established. So now they say that because they are not able to show per se, they are now, in order to establish the case, they have to do so under a different analysis, a more difficult analysis, which is known as the rule of reason analysis. Agreements that do not, and the courts have held that this is basically a definition of what rule of reason is. Agreements that do not fit within an established per se category are analyzed under the rule of reason. Courts will engage in a comprehensive analysis of the agreement's purpose and effect to determine whether it unreasonably restrains competition. So again, the court will have to look at everything in its totality and determine whether or not what happened was plausibly done to restrain competition. And plaintiff's assertion is that is true. Plaintiffs refer to the market for retail broker services, the market for clearing services, the market for relevant securities, individually or in the aggregate. And while plaintiffs assert flatly that their argument is that restricting purchasing shares in relevant securities reduce competition, they never articulate competition for what or between whom. But that's not true. They do articulate competition for what and between whom, between the retail investor and the short seller. Then they go into a brief talk about how they don't believe that the Dodd-Frank Act savings clause applies in this case, but they say plaintiffs try to shoehorn their claims into the Dodd-Frank Act savings clause by asserting that provisions of the Dodd-Frank Act touch upon issues alleged in the complaint, namely short selling, but the antitrust conspiracy that plaintiffs allege in this case concerning trading restrictions, defendants simultaneously exposed on their stock trading platform, not any short selling activity. So they're saying that these restrictions were not directly related to short selling activity, but in fact they were. They're just trying to argue their way out of this, Dodd-Frank exception. But I think that a reasonable judge will see that this was in fact short selling activity, and this does fall within the Dodd-Frank Act exception. Defendants do not and cannot demonstrate how cutting off retail investors' access to securities market by restricting trade is central proper function of low-rated markets. That's what was argued by the plaintiff. The defendants say that was central to the proper function of well-regulated markets. The SEC has recognized this principle in the related context of requiring brokers with market access to have risk management controls and supervisory procedures in place to systematically limit the financial exposure of brokers or dealers that could arise as a result of market access. So they're still trying to assert that this is an SEC claim in antitrust clothing, and they are just saying that there's plenty of laws out there and rules out there that the SEC have in place that would enforce and protect individuals. However, there really is nothing that is currently on the books right now that would protect retail investors from this specific set of facts. They're trying to basically lump it in with all these other rules. Plaintiffs assert that defendants cite to no law that would be in conflict with the underlying plaintiffs who claim to succeed. That is untrue. Defendants cited to SEC's comprehensive regulations for broker-dealers. They're saying that the broker-dealer rules, fit this squarely within the SEC. Again, it's similar to how they say, oh, well, plaintiff says one thing and then they say another. It's similar here. The defendants are saying there is a rule, but then at another point, they're saying that, this has been heard of before, but it really hasn't been heard of before. So they sort of are flip-flopping on their arguments in their reply compared to how they asserted it in their underlying motion to dismiss. So again, guys, I'm sorry I rushed through it. Like I said, I was really tired tonight. I had a crazy day, and I have a busy week ahead with setting up the interview for Lisa on Friday. I want to do the video tomorrow on the difference between multi-district litigation and class action. And then Friday, I also have an interview lined up on the gist. So sorry for the rush video. Sorry if it's not as good as the other ones, but I do appreciate you guys and all the support you've shown me. If you have any questions, never hesitate to ask. For now, the Lawyer of the Apes is adjourned.